Hi, everybody. This is an expert advice Q&A session with Hanna Stotland, who is an admissions consultant, member of the International Educational Consultants Association. I hope that's the right name. I'm Emil.
Independent Education Consultants. Pardon me, now I'm getting it wrong. It's the Independent Educational Consultants Association and also the Higher Education Consultants Association.
Okay, great. Thank you so much. So I'm Emil. I'm Director of Advising Services. So I've had past experiences in research as well as in admissions and pre-health advising. And I'm really glad to introduce Hanna to the general audience that's going to reach this video. And we're going to focus a little bit more on advising students or advising applicants, certainly in a little bit more generalized terms, not just for medicine, but also even to some insights into law and college and other sort of things. So in general admissions questions for individuals who seem to have that weird, a little blemish on their application related to things like institutional actions or possibly some civil citations and so forth. So that's going to be the focus of this conversation that we're going to have. I just want to make sure everyone knows ahead of time, there has been, we have no financial disclosures or financial arrangements associated with this conversation. So it's really, a really free for all in terms of like really getting some insight about from our perspectives as admissions, or her perspective for sure as an admissions consultant in this field since 1999. So it was a long period of time, a good history of working with students, and especially over the last 26 years, sort of the ups and downs of the internet and all of this sort of stuff nowadays. So I really appreciate Hanna joining us for this conversation. So let's first of all just get started with introducing yourself and sharing your expertise and background with us.
Great. Well, thanks so much for having me. I love these conversations with my colleagues. And I got into this field because I flunked out of high school. I had straight Fs my last 3 semesters of high school. I had a lot of problems with mental illness and also with a kind of misplaced rebellion. I thought it was like civil disobedience to refuse to do my homework. I thought I was like a conscientious objector to high school. I got a GED. I worked for a couple of years, eventually decided that I wanted to try going to college, but didn't know if anyone would take me. A small women's college gave me a chance. I did really well there and transferred to Harvard College, where I got a job in the summer in the admissions office giving tours and info sessions. And there's a part of the tour script says, you're supposed to say, and this is what brought me to Harvard. And I give a little thumbnail of version of my backstory the way I just did for you. And people were really not expecting to hear this from a tour guide at Harvard. And so what started happening right away while I was still an undergrad is families would take me aside after a tour and say, you have to talk to my nephew. He just got out of rehab and he wants to apply to college. Can you help us? And so people started bringing me consulting work, but specifically crisis management work. I didn't have that language at the time, but I saw dropped out, kicked out, flunked out, students who'd been expelled, suspended, arrested, sent to rehab, and at different levels. So I stayed at Harvard for law school. So starting in the summer of 1999 was a time when I began to work at all in the graduate school space. I was working for Kaplan that summer, teaching the LSAT, doing some law school admissions counseling. And starting then, all through law school and during my 6-year legal career in Chicago, I was an IEC on the side and always kind of hoping to do this when I grew up. After I left legal practice, I spent some time on the career counseling staff at Northwestern Law in Chicago. And then I've been doing only this full time since 2013. And over that time, I've specialized more in crisis management. But what that has meant is it's broadened my experience in terms of different types of admissions contexts within which students need to make difficult disclosures. So that is the center of what I offer students is how can you tell your best honest story? What is the best way to talk about the last thing in the world you want to talk about? And so that has included medical school as well as other health sciences.
So thank you so much for at least the recap and the background. And I really hope that anybody who runs across this video really appreciates a lot of a lot of what you bring to the table in talking in general terms in this conversation anyway, about what we're going to talk about soon. So let's start off at least with the basics for everybody who is not familiar, by talking about how we define institutional actions. So a general definition, and then of course this leads to this question, and if there are any differences in the admissions processes for law, medicine, even undergrad, college, or other graduate programs, about what institutional actions or academic actions and background checks are like. What are we all looking for in sort of a general broad admissions term, as well as the commonalities and the differences?
So a commonality is answer all questions truthfully on any application, even when it hurts, and sometimes it hurts. That being said, how these questions are phrased and whether they're asked at all varies a great deal between different kinds of programs, and sometimes from school to school within one field. And so one thing we can universally say is that medical and law schools are going to ask searching questions. How far back those questions go can vary. So in other words, whether they ask you about things that happened prior to college, that can vary. But we can understand where the institutions are coming from as they make choices about what to ask applicants. Because law and medical schools exist in order to provide a pathway into licensed professions that have a character component to licensure. And so that is really different from if you are, say, a master's program in computer science, or even an MBA, or a bachelor's program for the most part. Even if you're preparing someone for an accounting or civil engineering exam, the character and fitness investigation at the licensure stage is not the same. And so institutions are worried about, I am judged, especially law schools, I am judged on the pass rate of my students when they become my alumni. I'm saying if I'm the law school, I'm judged on this. And so if I'm admitting a student who, as we would say, is not barrable, they're not going to be permitted to take the bar, that is usually very damaging to me as an institution. And I don't want to waste a seat on that. That's not going to contribute to making my institution look good in the future. Mm-hmm. So this is all something to think about. But medical school and law school are consistently, at a bare minimum, are going to ask, has there been an institutional action? That's the MCAS language. Or a criminal history. At a minimum, you're going to be asked about that, and you need to level with them about that. Other types of programs vary enormously in what they ask and how much they're going to care about the answer.
Mm-hmm. Well, great. Thanks. Again, I appreciate the comprehensiveness of the answer. And as I said, any opportunity to sort of flip between law school and med school admissions for comparative purposes, I appreciate, just because you're right that both of those professions are very character driven. And it's interesting from my standpoint to see how everything compares, especially across all the health professions on my side of the house. So I appreciate it. You said you'd at least had a little bit of insight, and I want to just say, I want to try to get your experience if you happen to know how, in general admissions committees or even leadership within admissions committees, how they manage the disclosures that come from, a self-report for, an institutional action or criminal history or something like that. So from your insight, from your perspective, what are the different ways that gets managed in the application process?
Yeah, so I learn a lot about these things. Hi, Kitty. I learn about these things through all my collaboration with my colleagues on the institutional side of the desk. And the first thing I want to say that has been just universally confirmed throughout my experience is when institutions say we read these with care and individually, they do. And even if you want to be really cynical about it, reading applications all day is a very hard job, right? During reading season, they're long hours, lots of coffee, and a lot of, it's a slog, right? And these disclosures, interesting, right? If you read 100 essays that are all the same, and here's, I broke my leg when I was a kid, or my grandma got cancer, and this inspired me to be a doctor. After 100 of those, you have, here's how I got caught with drugs in my dorm room. I'm interested, right? So even if you're very cynical about the professionalism of institutions, which I'm not, but even if you are, there's a kind of selfish motivation to be like, ooh, well, we as humans are really interested in other people's dirty secrets. We
Sure.
just are. We look at the audience for soap operas and romance novels and all of this. And these IA disclosures are often about sex, drugs, and rock and roll. All right. So they're interesting. People really read these. The most common thing that happens is that there's usually a two-tier process. There is an initial read by the admissions folks, the people who this is their central job, as opposed to people who are sort of loaned by other departments. If that initial read says we're not interested in this candidate, then that'll be the end of the road for that school for that candidate at that school. If they want to take the student, then there's frequently a second level of review where the full-time admissions folks will gather a committee of folks from around the university to do a second review of the files that present special challenges. So that second read can include usually the dean of students, sometimes someone from the dean of the institution or the president of the college, someone from that office, from public safety, if there is an element there, from residence life, if the institution operates housing, can be someone from counseling and psychological services, if that's relevant, can be the general counsel of the institution. And if there's a sexual misconduct element, someone from the Title IX office. So the folks in charge of gender and sexuality related civil rights. That is a tough crowd. And if you're the student who's trying to get in, that is your real audience. Those are the folks you have to commit and to convince. And that is central to the challenge of writing these disclosures well, because any admissions essay you should be writing, bearing in mind who is my reader and what do they care about, right? It's very easy to tell people about the things that you want. We should be thinking about what does my reader want? And that is especially challenging here because those people want different things. If you're the dean of students, if you're public safety, if you're the general counsel, your job is to avert risk for the institution. That's a really different mindset to bring to the committee than, say, the mindset of admissions, which is about matching students with opportunities, filling the class with strong candidates. It's a really different mindset. So writing for that diverse crowd is a big part of the challenge.
That leads us pretty much directly into the first major question about general advice, knowing that there are these different audiences. And again, I know we gave an example certainly at the undergrad level, and there's sort of variations that certainly happen on the graduate professional level too. What general advice have you normally given to many of the people who've sought advice from you about how to start approaching the process of disclosing an institutional action? Obviously, aside from reading the prompt and any sort of legal minutia, which obviously would probably be part of the story, but I want to get a sense of how does one, begin the process of knowing how to self-disclose?
So the first thing to understand is, as we learned from Watergate, it's not the crime, it's the cover-up. And I can't tell you how frequently it happens where someone may come to me only after they have inadvertently made the problem worse.
Yeah.
Right? Where there some institutional actions are very, very minor, like having a candle in your dorm room. But you were written up for that. You're looking at the actual text of the question and it covers this. Disclose it. Nobody cares that you had a candle in your dorm room. They care very much about whether you are honest and show integrity on all those documents that go out over your signature. And this is especially deeply important for people who are going to be lawyers and doctors, who are going to be in positions of power over vulnerable people. And you are going to have state sanctioned power over the money and over the bodies of your fellow citizens. This is a really big deal. And that's why they take this so seriously. So the first thing is to understand, definitely don't make a small problem bigger by making them feel like, well, but now you've committed obstruction of justice effectively. So that's the first thing. A second important thing to know is that your reader is not interested in relitigating whatever happened before. And there are often very good reasons. You know, you had defenses to this arrest, to this finding of academic misconduct. That's extremely common now, especially in the medical school space. That's by far the largest group of IA disclosures that I see is where there's academic dishonesty, or at least a finding of academic dishonesty, sometimes which is disputed. If you disagree with the decision that your school made about your responsibility for this violation, it's fine to say that in so many words. I disagree with the finding that they made. This wasn't the correct outcome. Here's what really happened. But it is never in your interest to attack the institution, the process, the complainant, whether that's a professor or fellow student who may have turned you in, even if they richly deserve it on the facts, right? If you sued them, all of those facts really matter. That's a different audience. Here, what your reader cares about, what they need to understand is, who are you now? Who am I bringing onto my campus? Are you going to cause headaches and trouble and, God forbid, lawsuits for me in the future if I admit you? You know, if I'm the general counsel, I really care about that. And so that's what you should be emphasizing. If you state what happened was X, the complainant said what happened was Y, and the school found Y. They agreed that Y occurred. I was there, what happened was X. That kind of neutral factual statement is fine. But this audience is not there to review whether your college was right or wrong to find that you cheated. Talk about what that finding has meant in your life, how you act now, and how you're going to behave on their campus.
That's a really, really great point. And I know we don't usually share insights into when it's an appropriate opportunity, or at least how to talk about, disagreements with regards to findings. And especially, that's, we have a lot of applicants, especially, you probably know them too, a lot of findings of inappropriate use of AI. And
Yes.
AI uses plagiarism, and clearly it's like, so I want to try to get an essence of what would an effective answer look like, especially if one has to disagree. And
Yes.
I will have a follow-up with that in a second, but I'm really curious of how to construct an effective response, because we can obviously talk about, I accept the findings of guilt or whatever else. And, I'm interested in knowing how to talk about, I don't fully agree, but I'm going to accept the consequences or something like that.
Yes. And I think of any story, right? All human persuasion. We're learning more about this from our friends in psychology and communications research, in the political context, other contexts. All effective persuasion between humans is storytelling.
Mm-hmm.
Right? I mean, maybe if you're a mathematician, there's another way, but in any kind of verbal setting, it's storytelling. A story needs to have a beginning, a middle, and an end, or I think of them as acts 1, 2, and 3. And this very frequently, the space you get for explanation is very short, but you can do this in the space. Act 1, here's what happened. We can think about acts 1, 2, and 3 as the past, the present, and the future. So in the past, what happened? I did X. So for example, maybe I had another tab open on my screen during the exam, which was not permitted. I did not cheat, but I did have the other tab open in the browser, and I was given consequence X. That's act 1, is the facts of what happened in the past. Excuse me. Act 2 is the present. Here's what I'm doing now. So in the next 2 years of college, I've never been accused of any other type of academic misconduct. I have been volunteering, I've been working, I've been in school. You talk about everything you've been doing up to the point that you're writing the essay. And all of that is the present, and it shows your transformation from someone who got into trouble to someone who doesn't get into trouble. And act 3 is the future. What is going to happen? You are seeking admission into their institution. Tell them that you're not going to cause trouble, right? Because of acts 1 and 2, if done well, that makes 3 persuasive, where you're not just saying in a vacuum, oh yeah, don't worry about me. I only committed 1 axe murder. There's not going to be future axe murders. The statement, though, is really important to show I have learned something from this. This is a reflection that I did. Why was I? And you don't need to admit to anything you didn't do, but you should admit to things that you did do. And very often, even if you feel you didn't break the rules of the school, you may have had a failure of wisdom, a failure of kindness, a failure of risk management, right? Having that tab open, failure of risk management, the risk reward calculation there should have kept you from doing that. So those are the things that make it possible to persuasively say in Act 3, this is not going to be a pattern. If you admit me to your campus, I'm going to be a great citizen and not make trouble. I'm paraphrasing.
Right.
And so acts 1, 2, and 3, the past, present, and future, all need to be recognized in that disclosure essay, even if they give you some absurdly short space like 500 characters.
Yes.
You can have 1 sentence about each of those acts.
I was going to ask about what if the space they give you is insanely quick and short. I know one of the things that I always ask, especially on the med school side of things, is certainly try to find out what exactly was the citation that you were charged with in terms of, so from my standpoint, whenever I've been in the rooms discussing institutional actions, in my mind, the risk management in my head is, we will often ask a student conduct dean or whoever is in charge of keeping those types of records to disclose, what actually happened according to your documentation. And so one of the ways that I've always thought about it is, well, I don't want to be surprised. I want to know what's in that file, if that file exists and is not expunged otherwise. So that was another approach that I know I usually think about, especially if you're given a short, limited amount of space. So at minimum, tell us what we should expect. But for more longer, extensive answers, I really appreciate the 3-act model, which you're also giving. So I wanted to get a sense of, is that a good way of at least advising students to address it, especially if it's like really super short? In your opinion.
I'm sorry, could you repeat the question?
So I usually advise students to keep it generally short, but really a lot of the focus is if we were to ask the student conduct dean to tell us what was documented about your citation, what would it say? So I know I like to focus a little bit on that to be more of a conversation starter as opposed to a fuller reflection about what happened.
So that's a very smart way to think about things, is how would this look? There are a lot of parallels between the dating world and
Yes.
institutional admissions, where, if you're with someone who's divorced, one of the things that I would ask is, if I could talk to your ex, what would they say about the divorce? And a good person will answer that question. And when they answer that question, you don't want to hear, well, she was a monster. It was entirely her fault. That doesn't make this person look good. And the parallel is here, that even in a short piece, you want to acknowledge what is the best way of looking at the facts, what is the worst way of looking at the facts.
Mm-hmm.
And so it's key to say, the complainant, whether that was a fellow student, professor, whoever, their version of the facts is Y, and the school found Y, and what I did was X, right? But you're acknowledging Y. The reader needs to subjectively feel, even in a short piece, you can get a subjective sense that the author is hiding something, or that they are being candid, just concise.
Mm-hmm. Mm-hmm.
In many admission settings, it is possible to contact the admissions office and say, may I submit a longer explanation by email? Sometimes they will let you do that. Sometimes they will say, we'll let you know if we want that later. Start with your 500 characters. And you should use that judiciously. Often less is more, if we're talking about less in the sense of being efficient and not in the sense of hiding something.
Mm-hmm.
And remember that your audience is university administrators. Do not tell a story where university administrators are the villains. That is not how to persuade an audience effectively of their friends. Right? Many of us have gotten the advice in a job interview, don't badmouth your previous employer. And it's not because your previous employer wasn't abusive. Maybe they were. But what it causes strategically for you, it causes that interviewer to think, what's she going to say about me? So use that space efficiently. If you think it would benefit you to have more space, this is usually because Act 1 needs to be longer if the facts are very difficult and convoluted. So for example, I have lots of clients where there was more than one allegation.
Mm-hmm.
It is very difficult, even if they were all wrapped into the same disciplinary hearing. It is very difficult to acknowledge each of the, I would say, the hostile facts if there were 3 different matters. So aim for efficiency as opposed to just brevity.
Right. Okay, let me get to another question, which is going to be sort of similar. And obviously there's various gradations of these types of citations. So let's talk about somewhere, certainly in higher education, there's certainly an emphasis on not being too punitive for appropriately light offenses that happen. So that we'll do warnings or first offenses that don't go through some sort of ruling or conduct hearing or something like that. Well, a lot of students seem to have a lot of concern about these types of warnings, and they want to know, should they disclose or not? So what are some of the things that you've used to help students who may have had these first offense citations sort of figure out, how do they disclose, or should they disclose some of these first offense items? How do you help them kind of process through and either get them close to a decision to disclose or not?
So the wording of the question controls here. If they're asking about everything, tell them about everything, right? The author of the questions, these are the people who hold all the power. You should be bending the knee and saying, yes, sir, right away, sir. That's how the power dynamic in admissions, that's the reality. So if they say they want to know, you give them what they ask for, or assume that you're not going to go any further in that admissions process. That being said, there's a lot of this is particularly notable to me as a lawyer, because what lawyers like to have, this will be a reference for the 90s kids. We want to argue about what the definition of is. So the exact wording of the question matters a lot. So a typical way that this is worded in an undergrad context is, have you been found responsible for an academic or disciplinary violation since 9th grade?
Mm-hmm.
So if there was no finding of responsibility, then you don't have to disclose that. They didn't ask you about allegations, investigations, preliminary anything. If they found that there wasn't anything, or if they said, we're just going to resolve this informally, and we feel that the professor can handle it, let's say,
Right.
and then perhaps there is no finding of responsibility. Also, if there was, this comes up a lot again for me in college transfer situations, where they say, have you ever been suspended? And there was a preliminary suspension during the investigation. And at the end, you were not found responsible. I think you were suspended, right? Unless, again, there's a legal, part of the, I don't want to get too far into the weeds, but part of my sort of legal theory, understanding how university discipline works, is the punishment belongs to the institution that issued it. Mm-hmm. If they say this never happened, I am an expert witness and a consultant to many cases of litigation against universities for wrongful discipline of a kind. If you have a court finding or a settlement agreement where the school says this was our mistake, this never happened, that's different from, it isn't on your transcript, we didn't put it on your permanent record, whatever the hell a permanent record is. We use that phrase, it doesn't mean anything at all. In the days of paper files, perhaps it meant something, but doesn't anymore. Anyway, that's different from saying this did not occur. If the university says it didn't occur, then it didn't occur. And you may, with a clear conscience, say on an application, I've never been suspended. But short of that, unless you have something in writing from the institution saying you were not suspended, we're rewriting history. Short of that, if you were suspended, you were suspended, and you need to disclose it. But figure out the definition of is. It matters. Mm-hmm.
I've often also asked people who are applying, it's like, please work with whoever is in your who keeps the student conduct records. Yes. And there's definitely a way to know. You need to know, again, exactly how it was worded, exactly what the policies are, especially if that citation remains part of your file before it gets expunged or shredded or whatever. I usually love to just make sure it's like, what if you are going to be disclosing it, you need to be as closely matched or even identically matched to the language. Again,
that language, do not reword it.
Yes.
This is the opposite of the rule in an academic setting when it's important to put things in your own words unless it's in quotation marks with a citation. You need to use the exact words. If they gave you a letter or an email saying, we find this, find that document and use the exact same words.
Right. Mm-hmm. That, which, again, very, very important part that we tell people. One other question, which I probably could wait till later, but I wanted to bring it up. We have a lot of students for whatever odd reason, we're coming to the end of a semester, and they wind up in the weeks or whatever prior to beginning the submission of their application cycle, something pops up. I mean, I they get caught into some dragnet or whatever. I'm not entirely sure, but they get some sort of academic infraction that happens like near the end of the semester before they apply. So there's
or sometimes a week before graduation.
A week before graduation, yeah. What are your thoughts about having, because clearly not everything is resolved, everything is just begun. What sort of advice have you given to people who are caught in that type of situation?
If you can afford legal help, get legal help. There are lawyers who specialize in higher ed discipline. That is the specific, a lot of people, if you just look for an education lawyer, the most common thing that you get is people who work with disabilities, and is your IEP being respected and things like that. Higher education discipline is its own specialty, and you want someone who does that. Assuming you have no time or you can't afford that. Again, get back into the wording of the application. So in general, anything they ask you on that application, they ask you because they care about the answer. And if the answer changes after you have submitted your application, you need to update them and say, what I told you was true at the time, here's the new reality. Mm-hmm. As far as something that is unresolved at the time of application, you often have choices, and you have to make a strategic decision about which choice is best. So if a question is, have you ever been found responsible? And at the time of application, you have not been found responsible, but there is an open investigation and you've been told it's very likely that you're going to be suspended, then you might think about, is it better to disclose that up front? Mm-hmm. Rather than have to correct the record afterwards. And, if your lawyer or your advisor, whatever, think there's a real good chance you're going to be exonerated, then that is a reason maybe not to say, I'm under investigation, because it may be resolved in your favor. But the trade-off of that is that if you are found responsible, if you alert the graduate school to the existence of this investigation when it has been going on for 6 months, mm-hmm. I think that in some readers' minds, that can create a sense of, you were hoping to get away with this. You're not really candid with us. So it is worth thinking, again, if it looks like you're going to be found responsible, think hard about, is there any way I can get a strategic advantage by disclosing something now? And that's a judgment call that depends on a million different inputs. And it's something in my own practice that I'm usually going to be collaborating with the student's attorney to figure out what are the odds of these different outcomes? What is the timing of those outcomes? Are we going to not find out about this until a week before you're supposed to start medical school? Because in that case, there are a lot of situations where if we think this is something serious, like I see a lot of cases of alleged sexual misconduct. Mm. If you can't beat that rap, you're probably not going to get into medical school, at least not soon. That being the case, if you're not going to get in, I would rather you know that sooner, and you can adjust your plans and not have and I've seen this happen, not move to a new city, get a roommate and a lease and pay tuition. And then the school's like, wait, you didn't tell us about this? Or you right. Just now got suspended retroactively by your college? You can't start here. It's much, much better. It's painful. It's difficult. It takes courage. Prevent that problem by telling them sooner, even when even maybe when your appeal is pending, and in theory, your appeal might overturn that, so that you can live your life, right? Being admitted is not the only good outcome you can have.
Right. And it definitely doesn't mean, just because you're admitted, it's this cloud that just sort of follows you, and it feels it's sort of like you're hiding a real bad secret, and you're just sort of waiting for like the
Right.
shoe to drop or
And
whatever.
I can't. I'm never going to have a peaceful night's sleep for the rest of my life. Right.
Yeah.
Now, not that there are no right or wrong amounts of risk tolerance for a human being to have. I have a very low risk tolerance, and some people have more. But in general, people aiming for medical school are very type A, I want to control every contingency type person.
Mhm.
Most of us. Oh my God, how can you ever have any peace?
Yeah.
If you're like, so are they going to find out? And this is another issue. Is someone going to snitch on me?
Right.
It's not institutions that do that. It's usually other students or their families.
Mm-hmm. Yeah.
And you can talk about from your own experience when admissions offices get that email saying, did you know XYZ about your admitted student? You investigate that.
Certainly, if it's a very, very serious charge, such as a sexual misconduct or
did he not tell you, we were all part of a cheating scandal?
Yeah.
Did he tell you about that? Right? Because you're co-conspirators in any kind of wrongdoing. It's not just people who feel you victimized them too. But anybody who was maybe your accomplice and who is very bitter, maybe that you got into medical school and they didn't,
Mm-hmm. Mm-hmm.
they're going to snitch on you.
Yeah.
You better prepare for that.
So, yeah, no, I appreciate at least, discussing that, especially so many people are, again, on that fence on whether you should submit or whether you withdraw or whatever. So I thank you for sharing this conversation, because I'm not sure. It is definitely very dependent, certainly, on the circumstances.
I literally have a call later today. The next call on my calendar is about that topic.
Wow. Okay.
It's a lawyer and a potential client calling me to say, what do I do now?
Right. Mm-hmm. I wish you luck in the conversation. Obviously, yeah. I mean, again, you've been at it, and that's one of the reasons why, knowing some of the cases or some of the situations you've been involved with. It's like, this is the reason why I know I wanted to talk to you. Is it really helps me clarify a lot of how to think about the topic and how to help students too. So.
I've been around this block a few times. I've had, as of today, 354 sexual misconduct cases.
Wow.
Since
Mm-hmm.
2014. That's just sexual misconduct. And I've had a similar number of non-sexual. Next largest group is academic misconduct, but also drugs and substance abuse, stuff arising from mental illness.
Mm-hmm.
I see a lot.
Yeah. Well, for those who are still keeping us in this recording, we'll cover a little bit of that in a future question. Let me go for this one, though, which is, I think, certainly a lot more common given our current political era, where you have people who are involved in more civil citations, like they broke curfew, they resisted arrest. During COVID, it was like you had an unregistered guest come to your dorm, and so we have to write you up. So what are your thoughts, and how have you advised students under that type of a circumstance?
So this is different from just, say, drunk and disorderly, right? A resisting arrest. Now, we have kind of two different issues here. One is the upside, which is, this is not me acting a fool. This is me trying my best to make the world a better place. That's a better story to tell, right? For two resisting arrest cases, I'd a million times rather this is a protest versus I was over celebrating our sports win and resisted arrest. So
Yes.
that's the upside. The downside is your readers are human beings. They're going to have strong feelings, sometimes in conflict with yours. I see this especially in the last 2 years when there's been Palestine-related protests. This certainly can happen with ICE-related protests or stuff. There's plenty of people who were arrested back in 2020 over George Floyd, Black Lives Matter protest context, I would say.
Yes.
The Palestine context, I think, is the one where students are probably rightly most concerned that they may have readers who are passionately opposed to the cause that they support.
Hmm.
And I think that that is a valid thing to be concerned about. And again, you have to gently and factually talk about I was acting in accordance with my beliefs. I violated curfew, trespassing, whatever it might be. This isn't you should state the position you were advocating for, but this is not the place to try and persuade or justify, right? So that I think that there is a fair amount of patience for readers. These higher ed jobs are mission-driven jobs. This is part of understanding your audience. It makes, I like to joke, and I don't know if the students in the audience will get the joke, but counselors will. We don't go into higher ed for the money and the glory, right? There's no money and there's no glory.
Right.
It's not rational to work these jobs unless you actually care about young people and the enterprise of higher education and helping the process of matching students with opportunities. So in that sense, these are usually an audience who like young people, who believe in the enterprise of higher ed, and have some patience with the fact that students don't always perfectly calibrate the exact right way to protest or just how militant they should be and things like that. And in light of everything I've said, and you may get denied because they don't like what you did, right? That is a risk that you take with any kind of civil disobedience. Now, you can be arrested wrongly, and I think you can say that, right? If this was a First Amendment violation, because you are on public property and you had a permit and all of those things, it is reasonable to say we're currently litigating this, right? I'm challenging my detention. Again, it's not about, let me persuade you that my cause was just and that the arrest was wrongful. But rather, here is the context. I am a person who is committed to causes XYZ. And if there is an Act 3 thing that you can say, like, never lie. Okay, that's just a standard thing. So if you are potentially going to be taking over buildings when you're in grad school, in furtherance of your cause, don't lie and say you're never going to do that. But you also don't have to say, just wait till I'm admitted to your school, I'm going to burn the place down, right? There's middle ground there where you can say, being an activist is part of my identity. And also you can say, if truthfully there is a change, especially if this is a year or two ago and not yesterday, you can say, I believe that we went too far. This was a little more extreme than I intended. It got out of hand. And I'm going to be very careful in my future protests and exercising my rights. that I'm not stepping on anybody else's rights. And you're going to get in me a careful, respectful, and lawful protester. And there are plenty of schools who love those kids.
Oh, absolutely.
Where it's part of the mission of the institution.
And there's definitely a lot of other student organizations, certainly at the law and the medical school and the professional school level, that, you know, we do embrace that type of protest, appropriately peaceful and so forth. So,
right.
yeah.
We want the kind of people who are going to be making sacrifices their whole career in order to benefit vulnerable people.
Yep.
Right? You're applying to rural medicine or something like that. That's the whole point.
Mm-hmm. Exactly. This sort of leads into the usual next question, which I think is in general about what is usually discoverable in background checks. And so I know I have this one where it's like, we can talk a little bit about the different type of legal citations and the local nuances that come therein. But basically, this is just a general question about what usually gets reported on some sort of on these types of background checks. I'm guessing in law, you also, you know, they request background checks for admitted students, just like they do for med and dental and a lot of the health professions field. So this is just sort of this is the type of question that says, let's talk about background checks. So tell me what your thoughts are on that, or what gets reported.
Yeah, I have a little bit of a different perspective on this, which is I care very little about background checks. I care about what you're being asked.
Mm-hmm.
You can't control what comes up in a background check. You should, it's beneficial to be aware of it. And like permanent record, the word background check is incredibly broad and vague and can mean any of 100 different things. Different institutions and different government agencies use different vendors to conduct background checks. Those vendors offer different products. Right? If you're trying to hire somebody to be a defense contractor, you're going to buy a different product from the background check company than someone who's hiring teachers or someone, you know, it's almost like keep your eyes on your own work. The big issue is, are you being as candid as you should be with anything you are being asked? If something comes up on a background check that you didn't disclose, well, if you weren't asked about it and you're very sure that you read the question correctly, maybe, you know, go to a professor for help. If you don't have a lawyer, that's fine. You should be in the clear if something comes up that you were not asked about. So it's very hard to predict what a particular background check will turn up. Mm-hmm. And this is my last call earlier this morning was about what is going to come up. And also the question about, do institutions know what the wording of different decisions or civil processes? No, they don't. Typically, even a lawyer one state over will not know, right? And it's like different states call something a first, second, or third degree misdemeanor. Sometimes first is better, sometimes third is better. And for civil orders of protection or restraining order, or as this morning, an anti-stalking order, that phrasing is used differently in jurisdictions. So it does make sense. Don't assume that your reader, especially if this didn't happen in the state where you're applying, don't assume that your reader understands what something means. And all the different versions of wording, like sealed, expunged, reverse, dismiss, all of those things mean something different and might mean something different right over the state line. So you do provide context. If you say, so I got a second degree misdemeanor meaning XYZ for the protest.
Right. And obviously, a good local lawyer should be able to help you with that phrasing.
Yes. Yes. It's very common that non-lawyer defendants don't necessarily know the correct wording for their own situation. There's a reason why you have to go to law school and pass a bar exam for each state. This stuff is complicated.
And I'll admit, we don't pay university counsel to figure out all of those nuances either. And we try to help out with that. I know for us on the clinical medicine side, a lot of times it's a pro forma requirement for us to have students sort of work in clinical settings. So there's certain things that we clearly are, certainly a lot more important in regarding what gets reported on those background checks, especially when it comes to violence or assault or anything like those. Definitely are much more concerning, especially when we're talking about working with vulnerable patients. And that in general is usually, from my standpoint, when I had to listen in or participate in those conversations, that usually winds up sort of percolating as like a general trend, at least among the committees that I used to work with. So
yes, and it's and that is true. And at the same time, it's true that these folks are paying attention to the context you provide.
Right.
So I had a student, sometimes the label, this is why you should explain what the label means. Sometimes the label is very misleading. Like a student who is found responsible for sexual assault. And what this means is that 2 drunk kids were making out on a dance floor. Right now, according to the school rules, that's sexual assault. Schools are going to take it, graduate schools are going to take it very, very seriously, but it is not the same as a violent penetration.
Right.
Even though it has the same name. So don't just say, well, they don't give up because they put an awful label on something that I did that was wrong but minor. Right, anti-stalking. It was sending a single text asking how the person was. Not, I'm going to come to your house and kill you, single text. An innocuous single text, which he should not have sent. But at that point, there wasn't a restraining order or anything barring it. But the school found she had told you she didn't want to communicate with you anymore. And then you said a week later, how are you doing? So that's stalking.
Right.
Right. Okay. It's a technical violation. It was wrong. It's not going to be viewed the same as hiding in someone's bushes in the middle of the night. Right. God forbid. And all of those, there's a whole range of awful severity, and they're not all the same. Don't give up because there is a bad label on what you did.
But be very clear what you actually did do. So
be very clear about what you did do, and bravely say, I was found responsible for sexual assault. Here is the facts. And very often, like in the case of the drunken makeout session, everybody agreed what the facts were. There was only disagreement about what label or what punishment there should be. And in fact, in that case, the student only got probation. The school didn't view it as a danger to the community, but they called it sexual assault.
Right.
So be super clear about that. And that bad label is harmful and bad and terrible. And it'd be nice if you didn't have to disclose it, but you do.
Thank you for sharing that. I know, as I alluded to a little bit earlier, I'm sure we've all seen, certainly over the past few years, citations involving illegal substances and so forth. Even something we would think is innocuous, but you were smoking in a non-smoking dorm.
Or even vaping in the non-smoking area.
Yeah, exactly. So,
if it happened in high school, possessing a vape.
Yes. So, how have you dealt with those types of citations among people that you've worked with?
Just like everything else, just like in academic misconduct, sexual misconduct, criminal, protest misconduct. Be very clear. Here is my side of the story. Here's what was found. And if there is a substance abuse problem aspect to the story, oddly enough, I'm often kind of happy to hear that, because if there is Every reader in our culture understands the concept of substance abuse and the concept of recovery.
Mm-hmm.
It would always be better if this didn't happen. But if you have a story to tell, I went to rehab. I've been sober for 271 days. I go to 2 meetings every week. I am on drug-assisted addiction treatment, whatever the process may be. Everybody understands that. And it does not mean that this story of possession, selling, whatever is not going to hurt you. It still may. But I'm often happy to hear, just from a higher ed perspective, this is a story that everybody understands. If it is a true story, right, and it's on the pit actually both years, everybody understands this, and it's a complicated, serious issue. And recovery is real, and people do get better, and they sometimes get opportunity, a second chance at whatever they're doing. Now, if you just were having marijuana for fun and you were caught with it, that's unfortunate. Own it. And again, Acts 1, 2, and 3, if there has been a change, and say, I have decided that until I'm 25 and in a jurisdiction where it's legal, this won't be part of my life, right? If that's true, don't say it if it isn't true. But acknowledge your wrongdoing, even if you don't agree with our drug laws. You can acknowledge this was the rule and I broke it, whether it's a legal rule or a college policy rule that you were smoking in the wrong place. And here is how I currently behave differently and how I will behave differently as your student.
Mm-hmm. Any thoughts, obviously, with regards to recovery stories? That's obviously really obviously, I agree with you. A lot of those sort of, stories about overcoming challenges, overcoming obstacles, that's something everybody certainly in graduate and professional education, that's part of a journey story that we were all interested in. I guess there's still obviously a little bit of concern on the applicant side, exactly, of any sort of stigmas, especially regarding mental health and certainly abuse and so forth like that. And how have you encouraged people to sort of overcome some of those concerns about any sort of negative stigma that comes about that?
So that's real. I can't tell you, just tell the truth and people won't hold it against you. They may. I think my advice is tell the truth, even though people may hold it against you. I think there aren't a lot of ideal choices here where, you get to apply to graduate school in a stigma-free world or an unracist world or anything like that. We don't have that. Mm-hmm. I hope that you get a chance, you students in general, if you get a chance to become credentialed and help move us in the right direction and hopefully be a more nuanced leader than some of the people presently in power. All I can tell you is be brave and try to be open-minded. If this means, for example, it could, I get a chance to go to medical school, but it's a much lower ranked school than I was hoping for. That is a risk that may happen, and be brave about that and being like, well, I'm going to be a star there. Watch me get into AOA. Watch me get that orthopedic surgery residency or whatever aspirational thing that you want. Mm-hmm. And get the credentials to build the world that you deserve to live in.
Mm-hmm. And again, that I appreciate the words of advice and the confidence boosting for anybody who's trapped in this situation. Well, one other question before any questions that I missed. One of the questions that I do have is for people who are advising students, whether they're at high school, college, even current professional students who may have some of these issues or may be concerned about these issues, whether we're applying obviously to get into medical school or health professions programs, law school, or in the med students' cases, they're going to be applying for residency and they have to do similar disclosures and so forth like that. As student advisors, what are the things that we need to do to help support our advisees who are in such situations? What sort of things would you suggest would be important for us to be better advocates and supporters of students in those situations?
As you can see from my last answer, part of my philosophy as a counselor is don't sugarcoat things. I'm not going to tell you that people will not hold this bipolar diagnosis against you. They may, and I have a lot of students who have to disclose that because this is very, very common. They have a first manic episode, freshman or sophomore year of college, and they do something criminal. Often not a terribly evil criminal thing, but like using someone else's credit card. Very, very common criminal act in a manic episode. And I would like to live in a world where that student who, it's now been 2 years, they're consistent with their medication, they've never had another episode. You can be my doctor. Absolutely, you can be my doctor. But I'm not going to pretend that every reader is going to respond the same way. You get a panicky general counsel on that committee, you're not going to get in. So I think we owe our students that. At the kind of other end of the spectrum, we also owe to our students and to ourselves to encourage them to meet a very high standard of integrity. At the end, protect ourselves if we must. So I will fire a client if they tell me I am going to lie on this application. And it happens very rarely because I usually once in a while get a call from someone who sees crisis management and they think that means, oh, she'll help me with a cover up.
Right.
And I tell them lying is free. You don't need to pay me any money to lie. You need to pay me money to tell difficult truths. Right. But it does happen occasionally. And sometimes students are like, they say, I want to live on the edge. I'm going to lie on this application. I say, well, I have a duty of confidentiality. I'm not going to snitch on you.
Right.
Right. Unless they say they're going to harm somebody else. Right. Then of course I would have to. That's never happened in my practice.
Right.
But sometimes if you're independent, you have to quit / fire the client. And if you work at an institution and so it isn't, you don't control your portfolio of students, then this is a thing that you might have to go to the hierarchy of the school about and say, what are our policies for what I should do if I know or very strongly suspect that a student is going to be dishonest? I think that's important. A final thing is understanding our own limitations, right? If you're a brand new counselor, maybe this is a better case for your boss, right? Or maybe you can find a colleague at another institution to advise you. As the kinds of cases that we're talking about are not ideal rookie cases. So I think understanding our own limitations and reaching out for help, support, further education for ourselves is really important in providing the best support for those students.
Definitely. I appreciate you at least giving a lot of advice on that, at least on how we can better be effective advisors for and advocates for our students. I usually just ask this question because you're obviously, you see the clients and the students that you do see. Are there any other specific topics or questions that have raised your attention that you think we've missed in this conversation?
No, I don't think so. I think you've been really comprehensive. I'm just thinking about for students who are watching, from my perspective as someone who's been sort of in the weeds of this for 27 years, students and parents often don't have what I view as great instincts about what's more serious and what's less serious.
Mm-hmm.
And I see them making mistakes in both directions, being like, well, I had a candle in the dorm, I can never be a doctor. Like almost literally, like, oh, if there's an institutional action, it's all over for me. And I see overly optimistic students and families being like, yeah, but I have a great MCAT score. The fact that I was suspended for cheating senior year, like we can explain that. And I'm like, I don't have a magic wand. Like, I think I'm good at my job, but I'm not that good.
Right.
So I really encourage students and parents who are watching to, wherever you can, and you don't necessarily have to pay more to get professional advice. Maybe go to a few different people at your college. And even if you have graduated from high school or college, many times the counselors there are still willing to help and give you an idea of, is this as big as I think it is? Is this as reasonable as I think it is? Because if this is hopefully the first case like that you've ever dealt with, what seems very intuitive to me, that something is a small deal, is not intuitive to brand new folks who don't have any experience with admission. So just reach out for help, and you can often find help that doesn't require further expenditure. I'm not going to say anything that comes with college is free, right? You paid for that, but there's often not additional, you don't have to pay out of pocket all the time in order to get informed support.
Do you know of good, if there's law student pro bono clinics, or, obviously as like a first step to ultimately find people? I just want to, encourage that.
Yeah, I want to do a plug for a wonderful nonprofit especially for those of you looking at law school, barrierbreakers.org, founded by a brilliant colleague of mine, which has both a market rate admissions counseling business and a sliding scale. It is a nonprofit. It's a mission-driven organization. I don't know as much about what exists in parallel in the health professions space, but look for it. See what there is. See if folks at your high school or college know about it. There are places, community-based organizations and so on, that provide various kinds of higher ed support at low or no cost. So those are great resources to search for. I find this especially in my practice, but I'm sure that this is true in lots of different fields. Families don't know to look. If you're Googling and you want to find, is there someone who can help, someone accused of sexual misconduct get into law school? You'll find me, but you need to think someone is out there looking to help people like me. So that's a business challenge for me, but the same is true for all kinds of social service organizations. And sometimes even, I felt this when I was on the career counseling staff at Northwestern Law, which, boy, people were paying a lot of money to go to Northwestern Law. But they would often not think, oh, actually, I could bring this to one of those career counselors, and they would sort of ask the third year students for advice, and the third year students might or might not have good advice for you. But literally sit down and think, who could I maybe go to who, if they aren't the right person to ask about this, they might know who is. We saw that fairly often in the Career Center, where these, very able and, people in their mid-20s, they're not little children, think, oh, I can handle this by myself, and make a big mess with an employer or something, where it's like, oh, if you had just come in to talk to us about that, we would have loved to help you and save a whole lot of headaches for everybody. I've made that mistake many times in my life too, where I should have thought ahead and said, why don't I ask for help before there's a problem? So seek help.
Yes. And obviously that's ultimately a big sign of maturity and professional identity too, knowing when you need other people to help you before you absolutely need them. So.
Right. And I'm 50. I make mistakes where I'm like, oh crap, why didn't I ask a colleague about that? Of course I do.
Well, I definitely appreciate the opportunity to talk to a fellow colleague and an expert in an area that I sometimes know I need a little bit more confidence knowing what to say. So I really appreciate that you've been able to share your wisdom, Hanna, with anybody who comes across this video. And I appreciate you spending your time with us. Hopefully we'll cross paths again. And as I said, I wish you well with all your clients and whatever successes that come from your working with them. Okay.
Thank you. And I do want to invite my colleagues. I have a pro bono practice. I can't say, hey, every student with a question, call me. I'm not going to be able to handle that. But certainly if you're a counselor watching this on either side of the desk, and you have a question, I think it was probably obvious from this long interview, which thank you for your time. I love talking about this. I love thinking about the hard problems that my students are bringing to the table. And I love my work. And when colleagues call me or email me, please do that. And I'm going to spend probably a lot more time than I should, having virtual coffee with you on the phone, talking about the problem that your student is facing. So
and I definitely want to make sure I keep you on track on your schedule. So thank you so much again for all the time that you spent with us on this conversation. And again, I wish you the best of luck. And for anybody else who's joined, who's been following us and have come to and still with us to this point in this video, thank you so much for being part of this, at least listening to this conversation. And please get in touch with us at the Student Doctor Network, and we'll try to do our best to kind of address at least whatever your concerns are about your application or beyond. So thank you so much for spending your time with us.
Thank you. Same to you.